Judge, Supreme Court of India, to kindly deliver the welcome address.
Respected Shri Narendra Modi ji, the Prime Minister of India, Dr. Justice D.Y. Chandrachud, the Chief Justice of India, Mr. Justice B.R. Gawai, Judge Supreme Court of India, Mr. Arjun Ram Meghwal, the Minister of State for Law and Justice, Mr. R. Venkataramani, the Attorney General of India, Mr. Manan Kumar Mishra, the Chairman, Bar Council of India, Dr. Adi C. Agarwala, President, Supreme Court Bar Association, the Chief Justices and guests from Bangladesh, Bhutan, Mauritius, Nepal, and Sri Lanka, the Chief Justices and Judges of the High Court, advocates, officers, and attendees. Namaskar and good afternoon. Today we are convened to mark a historic milestone, the commencement of the 75th year of the Supreme Court of India. In 1950, when we adopted the Constitution, the three wings were assigned monumental responsibility of transforming a newly independent nation into embodying the values and ethos of our Constitution. Dr. B.R. Ambedkar's words, constitutional morality has to be embodied in nation building. It has to be cultured in a nation like India, where everything is newborn. To achieve this ideal, the Supreme Court of India is bequeathed with wide and expansive jurisdiction by the Constitution. Today, this court handles the highest volume of cases among the apex courts globally. Established in 1950, the court then had sanctioned strength of 8 judges. In the first year, it had pronounced 43 judgments. Today, the court has a strength of 34 judges and pronounces more than 1,000 judgments per year. This court's rich history is replete with landmark decisions echoing the aspirations of our founders. As we look back, let our reflections be more than an exercise in nostalgia. Let it be a pledge to fulfill our constitutional responsibilities now and in foreseeable future. The court does not decide en banc as a full court. Initially, the court was convened in larger benches, but presently the court typically sits in smaller benches of 2 and 3 judges. Despite the need for consistency and certainty, this ensures diverse representation and acknowledges varied perspectives within the judicial system. Nevertheless, there exists a harmonious coherence among the benches, contributing to the evolution of law and establishment of precedents. This makes the court widely accessible and prioritizes accessibility to common litigants of our country. While we take pride in the court's wide accessibility, it is imperative to acknowledge the rising cost of litigation. The two significant financial burdens are the expenses related to court hearings and the cost due to delay in the form of time and money for the individuals and business and the taxes for the government. Addressing these challenges requires innovative solutions, including adoption of technology that makes our court citizen-friendly and litigant-driven. At the International Lawyers Conference 2023, our Honorable Prime Minister, Shri Narendra Modi ji, had highlighted the importance of drafting laws simply without complicating their understanding. I must acknowledge that complex articulation often seeps into our judgments. Our judgments, though profound and impactful, should be simple, clear, and brief. This approach is not a departure from the legal rigor. Rather, it is a commitment to enhancing the accessibility of law. Judicial scrutiny of actions of the elected and the executive branches, commonly referred to as power of judicial review, varies along with a spectrum of high to low deference. The court positions itself in this spectrum after weighing the considerations of committee it owes to other institutions, but as an independent and an impartial institution tasked with upholding the Constitution, fundamental rights, and the rule of law. The judges, after hearing both sides, typically deliberate and render the decisions in solitude, a practice designed for in-depth appraisal. By engaging in individual contemplation, the judges aim to insulate their decisions from any undue sway of collective external pressures and to mitigate the impact of personal prejudices. This is not by any means an easy task or ordinary task. It's a responsibility that requires meticulous consideration and deep commitment to fairness. The great thinker Lasky, after enumerating hallmarks of a good judge, had said, and I borrow from him, a good judge is perhaps the rarest of all human types, for in being supremely himself, he must yet be supremely selfless. A society and a system that produces good judges can feel some real assurance about its future. In honoring the 75th year of Indian Supreme Court, let us affirm our collective commitment to these goals and ideals. Thank you and Jai Hind.
Thank you so much, sir. I would now like to request Dr. Adish C. Agarwala, President, Supreme Court Bar Association, to august the August gathering. Thank you.
I welcome all esteemed dignitaries to this August gathering. I feel proud that Honorable Prime Minister Shri Narendra Modi has spared his valuable time to celebrate commencement of Diamond Jubilee year of our Supreme Court. The Supreme Court of India has made its marks for being completely independent, inclusive, diverse, and has stood firmly behind the ideals enshrined in the Constitution. During my visits to different countries as President of International Council of Jurists, whose headquarters is in London, and as Vice Chairman of Bar Council of India, I noticed that our judgments are being cited, studied, and often followed by their courts, and I am referring not only to South Asian countries but also courts in Europe. Under the leadership of our Honorable Dr. Justice D.Y. Chandrachud, recent times have seen the judiciary rise to meet different challenges with active use of technology and video conferencing. The Supreme Court has also decided important cases like Ram Janmabhoomi Babri Masjid dispute, same-sex marriage, abrogation of Article 370, and triple talaq. These decisions have enhanced the faith of the people in the Indian justice delivery system and are acclaimed throughout the world. Our judges worked hard even during COVID times when most countries and their judiciary were not functional. The system of video conferencing, introduced and promoted by Honorable Dr. Justice D.Y. Chandrachud, has been a huge success. Since COVID-19, the High Courts and the District Courts in India have heard nearly 3 crore cases, and the Supreme Court heard more than 5 lakh cases in virtual hearings, making Bharat a world leader in virtual hearings. I am delighted to note that the current government of India does not resist any decision of the court which is aimed at bringing about a more equal and empowered society. Regarding the justice delivery machinery and its reforms, the government is being seen as a partner and not as opponent of the Supreme Court. On all fronts now, Honorable Prime Minister Shri Narendra Modi has provided a vision and a roadmap for the country to follow. We often hear the chant, Modi hai to mumkin hai. We have seen this happen in reality when bold decisions were taken one after the other during his leadership, which placed India on the expressway to becoming a superpower. Things which seemed impossible were also made possible because Modi ji took keen interest in the detailing instead of simply creating machineries half-heartedly. Leaders from most of the countries recognize you as a visionary statesman. You have also played a vital role in bringing about world peace and stability through diplomacy. Respected Prime Minister, you have recently overhauled the criminal laws and the law of evidence by bringing in new statutes in keeping with the changing times. This will strengthen our response to crimes and will enhance the faith of people in the law enforcement machinery. Honorable Prime Minister, as the President of the Supreme Court Bar Association, I may bring to your kind attention that our demand for providing chambers and cubicles, medical and life insurance to every regularly practicing member and the enactment of Central Advocates Protection Act are now pending with your government. Honorable Law Minister Sri Arjun Singh Meghwal has promised that the government will fulfill these long-standing demands. I am confident that these demands will also mumkin under your regime. I conclude by assuring both Prime Minister and Chief Justice that just as the government and the honorable courts have provided support to us, the bar to render all cooperation in all initiatives that help to bring people closer to justice. Jai Hind.
Thank you so much, sir. May I now request Shri Manan Kumar Mishra ji, Chairman Bar Council of India, to address this august gathering.
Dignitaries on the dais and off the dais, we have gathered here to celebrate the Diamond Jubilee year of our Supreme Court. On this occasion, I would first acknowledge the outstanding contributions of the former and sitting Chief Justices, judges, and stalwart lawyers who have helped the Supreme Court earn its reputation as one of the finest judicial institutions in the world. Started with 7 judges with 1 Chief Justice, our Supreme Court has 34 judges today. Our Supreme Court is said to be the most powerful institution in the world. It has delivered several landmark judgments to uphold the supremacy of the Constitution and the fundamental rights guaranteed under it. Our Supreme Court fully recognizes the powers and supremacy of our Parliament also. In abrogation of Article 370, same-sex marriage matter, the Supreme Court refused to interfere, saying that these are the domain of the Parliament. The concept of public interest litigation is the innovation of our Supreme Court. Perhaps no other court in the world had been exercising this extraordinary jurisdiction. During COVID, as told by the previous speakers, the doors of Indian Supreme Court were open for every needy person. Respected dignitaries, on this momentous occasion, I must highlight the achievements of our Supreme Court under the leadership of Dr. D.Y. Chanchud and other honorable judges of Supreme Court. The ideas and initiatives of information and communication technology are superb under the present CGI. Hybrid hearing system is the game changer for the courtroom access. Integrated case management and information system, translation of judgments in almost all important regional languages, online appearance portal, all new e-filings, e-Seva Kendraj, use of artificial intelligence, free Wi-Fi in premises, renovation of Judges Library, Vidhi Gyan Sampada, Training Hall, e-copy module, data management and automation, live streaming of Constitution Bench hearings. These are all the historic achievements of our ever young, smart, and handsome Chief Justice of India, Dr. Chanchud. And also all our knowledgeable, sincere, diligent judges of Supreme Court sitting here today. We feel proud when we see and we hear that Cambridge, Oxford jail, सब जगह हमारे चंचूड़ साहब का डिमांड है. Sir, our honorable judges hear 60 to 100 cases daily. And in every case, they are well prepared. I can emphatically say that no judge of the top court of any other country has the capacity or zeal to do such hard and complicated works. As a member and the leader of the bar, I must say, to criticize any system is very easy. But one should be aware of the ground realities also. The backlog and dependency, that is the biggest problem not only before the Supreme Court but before all the high courts and lower courts. But why it is there? It is because of the immense faith of the people in our judiciary, in the Supreme Court. One should realize that. We need more judges at all levels. And one more thing, the leaders of the bar are here, the Supreme Court leaders are here. Rosters, what matters should be listed before whom, is not the job of the bar. It is for the Honorable Chief Justice and the Honorable Judges to decide. We are to protect the rights, privileges, and interests of the lawyers, but at the same time, we have some limitations also. We should always keep it in mind. Now, something about our Honorable Chief Guest, Honorable the Prime Minister of India, who is sitting here on the dais. Ram Lala's case, a decree was passed in the year 2019. It was affirmed by the Supreme Court, but it was not so easy to get it executed. You all know the region and the situations existing at that time. Sir, it required a very strong willpower, confidence, dynamism, and expertise, political skill, along with 56-inch ka sina to get it done. Otherwise, the judgment and decree would have been proved futile. On 26th of January, I was in Patna. A few of my school friends, they came to me. As a lawyer, I can say, as a judge, I can't. What will happen to Lok Sabha elections, sir? आप तो चेयरमैन हो बार काउंसिल ऑफ इंडिया के, आप हर जगह घूमते रहते हो. अभी 24 में क्या होगा? उसी में से एक ने जवाब दिया, अरे होगा क्या, इससे बढ़िया क्या होगा, जो हो रहा है वही होगा. Why? There is no unemployment, almost nil. गरीब कल्याण रोजगार अभियान आ गया. Daughters are no more liabilities. बेटी पढ़ाओ, बेटी बचाओ. One said that my 2 daughters are IT engineers. 1 मिनट में मोबाइल से पैसा ट्रांसफर हो जाता है. And this is the all gift of our honorable the chief guest sitting here today. This technology, this has made everything easy. Our economy is growing very fast. Not only the reservation for females, bijli, pani, faster trains, airport, markable increase in foreign investment, grand success of Chandrayaan's landing, vocal for local, make in India. Now today we are 5th largest economy in the world. Asian Games record, victory हमारी. List of achievements can never be complete. बिहारी भाषा में एक ने बोला, सारा बड़का बड़का देश का शेर लोग हमारे मोदी जी के आगे भींगल सियार लगता है. This was the word used by one of my friends. पहले भारत का प्रधानमंत्री लोग विदेश के आगे में आते थे, आज सारी विदेशी ताकतें हमारे मोदी जी के आगे घिस जाती है. Sir, it's a very auspicious occasion today that the two big personalities, hero of the world's judiciary and the political hero of the world, are sitting together on the dais. पांच सौ वर्षों तक झेल रहे करोड़ों भारतीयों को मानसिक पीड़ा से उबार कर हमारे रामलला को पुनः भव्य राजमहल सा मंदिर बनवाकर देश में राम राज्य की पुनर्स्थापना करने वाले युग पुरुष, विश्व के सबसे लोकप्रिय, प्रभावशाली और शक्तिशाली राजनेता, विश्व भर में भारत का मान सम्मान और शान बढ़ाने वाले ऐतिहासिक प्रधानमंत्री माननीय नरेंद्र मोदी जी को देश के 25 लाख वकीलों और 140 करोड़ जनता का कोटिशः प्रणाम और नमस्कार, आभार. सर, आप स्वस्थ रहें, दीर्घायु हों. भगवान आपके नेतृत्व का लाभ इस देश को प्रदान कराते रहें. आने वाले समय में आपका नेतृत्व, हमारा भारत और शक्तिमान बने आपके नेतृत्व में, यही कामना है. जय भारत.
Thank you, sir. Moving ahead, I would now like to request Shri R. Venkatramani, Learned Attorney General for India, to say a few words on this historic occasion.
Honorable the Prime Minister of India, Honorable the Chief Justice, my respectful regards through the galaxy of gathering here today. My heart jumps with joy on being part of this occasion. And it's a moment of great pride and pleasure to be part of an event celebrating 75 years of the Supreme Court of India. On the Republic Day, we saw the demonstration of the commitment of the nation to women's empowerment. In a significant step, the Supreme Court, playing its own part, has designated a number of women lawyers as senior counsel. These are not merely symbolic. Steps such as this in the nation, in the legal profession, and in the court shows momentous transition into the world of equality. Constitutional values and ideas emerge from social and political mobilizations. While courts do not lead such mobilization, they are an essential part of giving new and distinctive articulations. It's a matter of great pride, too, for every member of the legal fraternity to appreciate and stand by some of the most remarkable constitutional and jurisprudential doctrines and values the Supreme Court has not only articulated, but they ensured their entrenchment in the course of 70 years of its history. It goes to the credit of the Supreme Court and the High Courts that in the early years of the court, women and men of ordinary social position reached the courts and their causes came to be adjudicated. Today, the access to justice expands is a legal universe of its own. Unlike ordinary legislation, the Constitution is a document to be celebrated every day. A day in the life of a citizen is marked by several interventions as well as facilitations. So it is in the life of a nation that we move into an interconnected world. Every day will be marked by interventions and challenges. The citizens look up to the governance at the nearest level to be able to conduct and manage one's transactions with ease and comfort. The Constitution is a document of guarantees and freedoms, and the codification of power may seem to be a distant document for everyday life, but it is not. As we move from the index of one day to an index of larger periods, we begin to measure the impact of law in our life. This is where the chronicles of the life of a nation and what we call progress in the arrangement of the affairs of the nation becomes important. Compared to the long history of more than 200 years of the United States of America, with the birth of its Constitution in 1789, and compared to the constitutional history of England for the days of Magna Carta, or even compared to the constitutional history of some of the European nations, 75 years of our constitutional history may seem to be relatively small. But if one looks at what one may describe as the features of the Constitution and their impact on the lives of the people, we can say without being contradicted that 75 years of Indian constitutional history is as good as and as sound as comparable to any constitutional history. When we are assembled to talk about 75 years of the Constitution, we are talking about the transformation of the Constitution to the judicial process, and particularly to the Supreme Court. It's not possible to talk about the transformation in the Constitution without talking about the court. For constitutional scholars who talk in terms of constitutionalism, constitutional history is confined to or drawn in terms of performance by and functioning by institutions of governance. And there's also a shaping of the Constitution by judicial institutions. While this may be, to some extent, good focus, an equally important facet is the abiding faith of the people and the people's participation in the democratic process, and the pledge they have extended to the idea of a nation, its integrity, and their nexus and deliverance for the lives of the people. The Constitution, therefore, works when there is a confluence of citizens and the institutions, and when they stand together and the one does not fail the other. The endurance of the Constitution is the most important feature of the Constitution. The endurance is a contribution of the legislatures and the governance institutions and the judicial institutions. This contribution to the dynamic balance, political morality and governance accountability, about which Baba Sahib Ambedkar ever emphasized in his writings, are twin driving forces that can keep democracy vibrant and alive. So also the unfettered roles of the courts in ever being ready to explore the contours of citizens' rights and governance obligations, without, of course, sitting heavily on governance responsibility and governance initiatives. What governance does by right choices generates faith in democracy. What courts do by ensuring against wrongs of governments generates confidence in the Constitution. 75 years of history of the Supreme Court is a rich treasure house of law and jurisprudence. The contribution of the Supreme Court can be said to be unique in the sense that it has comprehended the diverse roles of the courts, but all tuned to standing by the sides of citizens in ever being vigilant in their protection and promotion. While we have borrowed from elsewhere, we have our own demonstrations of native genius. The permeation of the native jurisprudential genius as part of rule of law in the country has to be measured on its own forms as a post-colonial narrative. The history of constitutional litigation, the court shows how it provided a window and option for ordinary citizens to occupy spaces hitherto held by the elite and the well-endowed. The promises of an egalitarian state where equal regard for all will be the governing mantra, while seemed far removed from citizens' participation at the time of the advent of the Constitution, got translated into an accessible pathway solely by reasons of the Supreme Court opening up its doors to all causes and concerns of citizens. To assess the state of constitutional adjudication, which happens in the highest court today, we can look at what was stated in the year 1951 by the then Chief Minister of the state of Hyderabad, unquote. An extraordinary tendency has been noticed recently for all sorts of people to take up cases up to the High Court citing provisions in the Constitution relating to what are termed fundamental rights. A woman has asked for a stay of an order served on her by a police asking her to leave the state for non-possession of a valid permit, while two displaced teachers were asked to pass a test of regional language have prayed for the issue of writ of mandamus, questioning the validity of the order. I quote, "This statement was a very narrow view of the role of the courts and citizens' access to justice. While there could be several points of view on the expansion of the role of the courts in dealing with the facets of governance, hitherto away from scrutiny by courts, it is the unalloyed assertion of independence of judiciary that has added richness and strength to the constitutional consciousness of the citizens of Bharat. Satya and Dharma are intertwined. They reinforce each other. Bharat will continue to symbolize both of these values of civilization. We pledge to be part of this constitutional consciousness. Jai Bharat.
Thank you so much, sir, for this insightful address, where your reflections on the Supreme Court's role and contributions were so beautifully woven together. अब मैं विधि एवं न्याय मंत्री श्री अर्जुन राम मेघवाल जी से विनम्रता पूर्वक आग्रह करती हूं कि वो इस सभागार में उपस्थित सभी श्रोतागण को संबोधित करें।
भारत के माननीय उच्चतम न्यायालय के 75 वर्ष पूर्ण होने के अवसर पर आयोजित इस भव्य कार्यक्रम में उपस्थित विश्व के सर्वाधिक लोकप्रिय नेता, विकसित भारत के संकल्प को सिद्धि में परिणत करने हेतु पूर्ण मनोयोग से लगे युग नायक भारत के यशस्वी प्रधानमंत्री आदरणीय श्री नरेंद्र मोदी जी, भारत के माननीय उच्चतम न्यायालय के मुख्य न्यायाधीश डॉक्टर D.Y. चंद्रचूड़ जी, जस्टिस श्री संजीव खन्ना जी, न्यायाधीश सुप्रीम कोर्ट, जस्टिस श्री B.R. गवई साहब, न्यायाधीश सुप्रीम कोर्ट, श्री R. वेंकटरमणी जी, अटॉर्नी जनरल ऑफ इंडिया, श्री मनन कुमार मिश्रा जी, चेयरमैन बार काउंसिल ऑफ इंडिया, डॉक्टर आदिश अग्रवाला, प्रेसिडेंट सुप्रीम कोर्ट बार एसोसिएशन, तथा उपस्थित माननीय सुप्रीम कोर्ट के न्यायाधीशगण, विभिन्न हाई कोर्ट्स के माननीय मुख्य न्यायाधीशगण, श्रीलंका, बांग्लादेश, नेपाल, मॉरिशस व भूटान के मुख्य न्यायाधीश, समस्त अधिवक्तागण, मीडिया बंधु, नारी शक्ति एवं समस्त श्रोतागण, सॉलिसिटर जनरल ऑफ इंडिया तुषार मेहता जी और विधि के सभी ज्ञातागण, ये हम सभी के लिए अत्यंत गर्व और हर्ष का क्षण है कि आज माननीय उच्चतम न्यायालय की यात्रा के 75 वर्ष के पड़ाव पर यह कार्यक्रम आयोजित किया जा रहा है। न्यायपालिका के सर्वोच्च संस्थान व संवैधानिक मूल्यों के संरक्षण के रूप में माननीय उच्चतम न्यायालय के अतीत को याद करके वर्तमान में प्रेरणा लेने व बेहतर भविष्य की कार्य योजना पर चिंतन मनन मंथन करने का ये महत्वपूर्ण अवसर है। लगभग 5000 वर्ष के वैभवशाली इतिहास तथा लोकतंत्र की जननी भारत की विरासत के साथ स्वतंत्र भारत में न्यायिक व्यवस्था के सिरमौर सुप्रीम कोर्ट के 75 वर्ष पूर्ण होने पर आयोजित इस कार्यक्रम के लिए मैं आप सभी को बधाई देता हूं। इस अवसर पर मैं ये कहना चाहता हूं कि ये मात्र 75 सालों की यात्रा नहीं है, बल्कि न्याय प्रणाली में भारत की सिविलाइजेशन परंपराओं तथा दीर्घकाल में सिंचित कलेक्टिव विजडम को भी सेलिब्रेट करने का अवसर है। न्याय व धर्म के सिद्धांत भारतीय सभ्यता में गहनता से समाहित है। सभ्यता के इस लोकाचार में जब जब नैतिकता के नेचुरल फ्लो में विकृति का आविर्भाव हुआ, तब तब कोर्स करेक्शन करने के हेतु न्यायिक तंत्र ने विभिन्न रूपों में अपनी भूमिका निभाई तथा न्याय शास्त्र का विकास किया। भारतीय इतिहास में चाणक्य नीति, विदुर नीति, बृहस्पति सूत्र, वेदांत, उपनिषद, धर्मसूत्र, महाभारत, गीता इत्यादि में न्याय शास्त्र के शाश्वत सिद्धांतों तथा उनके माध्यम से बेहतर राष्ट्र, समाज, परिवार व इंडिविजुअल बनने की निरंतर सद्प्रेरणा मिलती रही है। 300 BC ईसा पूर्व में रचित कौटिल्य के अर्थशास्त्र के 3रे अध्याय में व्यवहार यानी दो या अन्य पार्टियों के मध्य लेन देन अथवा विवाद के संबंध में हमें वर्णन मिलता है। मध्यकाल व औपनिवेशिक काल में भारत में भी समयानुकूल न्यायिक प्रणाली में परिवर्तन होते रहे। स्वतंत्र भारत के निर्माण में लीगल फ्रेटर्निटी का महत्वपूर्ण योगदान रहा। पूज्य राष्ट्रपिता महात्मा गांधी, संविधान शिल्पी बाबा साहब भीमराव अम्बेडकर, गृह मंत्री वल्लभ भाई पटेल साहब, वीर सावरकर जी, लोकमान्य बाल गंगाधर तिलक आदि ने भारत की नींव को मजबूत करने में अहम योगदान दिया। आज़ाद भारत में महापुरुषों ने जन आकांक्षाओं को समाहित करने वाले संविधान के रूप में पवित्र प्रेरणा पुंज देकर तथा लोकतांत्रिक व्यवस्थाओं के सुदृढ़ करने का एक मंत्र दिया। 26 जनवरी 1950 को संविधान लागू होने के 2 दिन बाद ही 28 जनवरी 1950 को पहली सिटिंग के साथ ही माननीय उच्चतम न्यायालय ने कार्य प्रारंभ कर दिया। औपनिवेशिक कालखंड के परिप्रेक्ष्य में देखा जाए तो अंग्रेजों के खिलाफ हमारी लड़ाई देश की एकता व स्वतंत्रता के लिए रही। अंग्रेजों की फूट डालो और राज करो नीति के चलते हुए बंटवारे के कारण हमें एकता को पार्शियली कंप्रोमाइज करना पड़ा, लेकिन स्वतंत्रता को बरकरार रखने में राष्ट्र ने बिल्कुल भी समझौता नहीं किया। भारतीय संविधान की छत्रछाया में स्वतंत्रता के इन्हीं मानकों को प्रगाढ़ करने की दिशा में माननीय उच्चतम न्यायालय ने महत्वपूर्ण भूमिका निभाई है। सुप्रीम कोर्ट में समय समय पर अपने निर्णयों से संवैधानिक मूल्यों को प्रगाढ़ किया है। इस यात्रा के दौरान सुप्रीम कोर्ट ने अनेक उल्लेखनीय माइलस्टोन क्रॉस किए हैं, जिनमें कुछ को मैं संक्षिप्त जिक्र करना चाहूँगा। केशवानंद भारती केस में सुप्रीम कोर्ट ने बेसिक स्ट्रक्चर के डॉक्ट्रिन के सिद्धांत की व्याख्या की। 1980 के दशक में जस्टिस PN भगवती और जस्टिस VR कृष्णा अय्यर की अगुवाई में एक पोस्ट कार्ड को जनहित याचिका का रूप माना गया। MC मेहता केस के परिणाम स्वरूप पर्यावरण संरक्षण अधिनियम 1986 के निर्माण को प्रेरित किया। इंदिरा साहनी केस में OBC के 27% आरक्षण को संवैधानिक ठहराया। विशाखा केस में वुमेन सेफ्टी एट वर्क प्लेस को महत्वपूर्ण आधारशिला रखी गई। 9 नवंबर 2019 को अयोध्या के राम मंदिर जजमेंट को भारत की ट्रस्ट विद डिविनिटी की यात्रा में मील के पत्थर के रूप में हमेशा याद किया जाएगा। 75 वर्ष पहले 8 न्यायाधीशों से शुरू हुई इस यात्रा में अब न्यायाधीशों की संख्या बढ़कर 34 हो गई है। अक्टूबर 1989 में जस्टिस फातिमा बीबी ने पहली महिला जज के रूप में पदभार ग्रहण किया। आज नारी शक्ति हर क्षेत्र में अपना प्रभावशाली योगदान देकर देश का नाम रोशन कर रही है। ये अत्यंत हर्ष का विषय है कि इसी श्रृंखला में उच्चतम न्यायालय में भी वर्तमान में 3 महिला जज अपनी सेवाएं दे रही है। आज इस देश में अमृतकाल में वर्ष 2047 तक विकसित भारत बनने का संकल्प ले चुका है। तब प्रधानमंत्री श्री नरेंद्र मोदी जी के नेतृत्व में होल ऑफ गवर्नमेंट अप्रोच से न्यायपालिका के साथ सहयोगात्मक रूप से बेहतर जस्टिस इकोसिस्टम बनाने हेतु हम प्रतिबद्ध है। ये हम सभी के लिए गर्व की बात है कि पिछले एक दशक में ईज ऑफ लिविंग के साथ साथ ईज ऑफ जस्टिस को बढ़ावा देकर एक सिटीजन सेंट्रिक टेक्नोलॉजी ड्रिवन मॉडर्न लीगल सिस्टम को बनाने की दिशा ठोस आधार के साथ प्रभावशाली प्रगति की है। जुडिशरी में डिजिटल इंफ्रास्ट्रक्चर को बढ़ाने के लिए सरकार मिशन मोड में काम कर रही है। इसी का परिणाम है कि भारत वीडियो कॉन्फ्रेंसिंग व वर्चुअल सुनवाई के माध्यम से डिजिटली जुडिशियल प्रोसीडिंग करने में ग्लोबल लीडर के रूप में उभरा है। वीडियो कॉन्फ्रेंसिंग के माध्यम से कुल 2.92 करोड़ वर्चुअल सुनवाई हुई। इनमें से 4,82,941 सुनवाई माननीय उच्चतम न्यायालय द्वारा की गई। यह एक रिकॉर्ड है। अभी हाल में स्वीकृत ई-कोर्ट फेज 3 के तहत डिजिटल पेपरलेस व स्मार्ट कोर्स स्थापित करके तथा यूनिफाइड टेक्नोलॉजी प्लेटफॉर्म के माध्यम से कोर्ट, लिटिगेंट्स व अन्य स्टेक होल्डर को जोड़कर नागरिकों व अदालतों को करीब लाने का सार्थक प्रयास किया गया है। जुडिशियल इंफ्रास्ट्रक्चर को बढ़ावा देने की दिशा में भी सरकार द्वारा सेंट्रल स्पॉन्सर्ड स्कीम फॉर जुडिशियल इंफ्रास्ट्रक्चर फॉर डिस्ट्रिक्ट एंड सबऑर्डिनेट कोर्ट क्रियान्वित की जा रही है। इसके माध्यम से कोर्ट हॉल भी बने हैं, जुडिशियल ऑफिसर के लिए रेजिडेंशियल यूनिट भी बनी है और ई-कोर्ट प्रोजेक्ट के अंतर्गत लॉन्च किए गए नेशनल जुडिशियल डेटा ग्रिड आज 34.35 करोड़ केस व 23.80 करोड़ ऑर्डर जजमेंट की जानकारी सिंगल क्लिक पर उपलब्ध करवा रहा है। अंतिम छोर पर गरीब नागरिकों को लीगल सर्विस उपलब्ध कराने हेतु कानूनी साक्षरता व जागरूकता कार्यक्रमों हेतु सेंट्रल स्कीम दिशा को भी हम संचालित कर रहे हैं, जिसके अंतर्गत टेलीलॉ प्रोग्राम के द्वारा 67 लाख से अधिक नागरिकों को प्री लिटिगेशन एडवाइस दी जा चुकी है। इसी तरह से भारतीय गणतंत्र के 75 वर्ष पूर्व होने पर वर्ष भर चलने वाले अभियान हमारा संविधान हमारा सम्मान का शुभारंभ डॉक्टर BR अम्बेडकर इंटरनेशनल सेंटर दिल्ली में माननीय उपराष्ट्रपति श्री जगदीप धनखड़ जी के द्वारा न्याय सेतु लॉन्च किया गया, जो कि टेक्नोलॉजी के द्वारा समावेशी रूप में कानूनी जानकारी, कानूनी सलाह व सहायता प्रदान करने का एक प्लेटफॉर्म है। न्याय तक पहुंच सुनिश्चित करने के लिए लैंग्वेज बैरियर नहीं बने, इसके लिए आर्टिफिशियल इंटेलिजेंस बेस्ड भाषिनी टूल्स के साथ साझेदारी की गई है। मैं इस अवसर पर विशेष रूप से उल्लेख करना चाहूँगा कि बाबा साहब डॉक्टर B.R. अम्बेडकर जी की वकालत के शताब्दी वर्ष के दौरान संविधान दिवस 26 नवंबर 2023 के अवसर पर माननीय सुप्रीम कोर्ट परिसर में वकील मुद्रा में उनकी 7 फुट की प्रतिमा स्थापित करके उन्हें पूर्वज अधिवक्ता के रूप में याद किया गया। इसके लिए मैं सुप्रीम कोर्ट को बहुत बहुत बधाई और धन्यवाद देता हूं, ताकि न्याय के इस मंदिर में स्थापित वकील की वेशभूषा में बाबा साहब की ये प्रतिमा संविधान प्रदत्त मूल्यों पर चलने के लिए निरंतर प्रेरणा देने के साथ साथ जिम्मेदारी का भी एहसास करवाती रहे। आज 21वीं सदी के कालखंड में वैश्विक समस्याओं के समाधान हेतु पूरा विश्व भारत की ओर देख रहा है, भारत में अपना मित्र खोज रहा है। सुप्रीम कोर्ट के नेतृत्व में भारतीय न्यायिक प्रणाली की इस यात्रा में देश ही नहीं बल्कि अंतर्राष्ट्रीय स्तर पर प्रभावशाली मानक स्थापित कर रहा है। आज विश्व भर के 40 से अधिक देशों के उच्चतम न्यायालयों ने भारत के सुप्रीम कोर्ट के जजमेंट को रेफर करके अपने निर्णय लिए हैं। ग्लोबल साउथ के देशों में न्याय की पहुंच को बढ़ाने के लिए 27 से 28 नवंबर 2023 को नालसा द्वारा UNDP, यूनिसेफ, इंटरनेशनल लीगल फाउंडेशन के सहयोग से फर्स्ट रीजनल कॉन्फ्रेंस ऑन एक्सेस टू लीगल एड स्ट्रेंथनिंग एक्सेस टू जस्टिस इन ग्लोबल साउथ का सफल आयोजन किया है। मैं इस अवसर पर उच्चतम न्यायालय के 4 जो जस्टिस दलबीर भंडारी, जस्टिस RS पाठक, जस्टिस नागेंद्र सिंह, जस्टिस सर बेनेगल राव, जो इंटरनेशनल कोर्ट ऑफ जस्टिस में जज के रूप में अपनी सेवाएं दे चुके हैं, जो कि विश्व में भारतीय न्यायपालिका की स्वच्छ, निष्पक्षता और प्रभावशाली छवि का परिचायक है। एक तरफ भारत विश्व की 5वीं सबसे बड़ी अर्थव्यवस्था के रूप में तेजी से विकास यात्रा पर गतिमान है, वहीं दूसरी ओर अल्टरनेटिव डिस्प्यूट रिजोल्यूशन के माध्यम से कानूनी मध्यस्थता का हब बनने भारत जा रहा है। मैं इस अवसर पर कानून और न्याय मंत्रालय ने जो विजन 2047 के रूप में जस्टिस फॉर ऑल का लक्ष्य प्रस्तावित किया है, इसके अंतर्गत स्पीडी, अफोर्डेबल एंड टेक्नोलॉजी इनेबल्ड सिटीजन सेंटरिंग डोर स्टेप जस्टिस डिलीवरी सिस्टम के द्वारा न्याय की सुगम पहुंच का लक्ष्य रखा गया है। आज अमृतकाल के अंदर आत्मविश्वास से परिपूर्ण भारत देश आत्मनिर्भर होकर 2047 तक विकसित होने के लक्ष्य पर आगे बढ़ रहा है। इस लक्ष्य की प्राप्ति के लिए एक मजबूत, निष्पक्ष एवं स्वतंत्र न्यायिक व्यवस्था के आधार स्तंभ के रूप में सुप्रीम कोर्ट महत्वपूर्ण भूमिका निभाएगा। न्याय का मंदिर बना रहे सर्वोच्च न्यायालय हमारा, न्याय का मंदिर बना रहे सर्वोच्च न्यायालय हमारा, संविधान का रक्षक बना रहे सर्वोच्च न्यायालय हमारा। आज अमृत वर्ष की बस यही शुभकामना है, देश का गौरव बना रहे सर्वोच्च न्यायालय हमारा। बहुत बहुत धन्यवाद।
धन्यवाद माननीय मंत्री जी। May I now request the Chief Justice of India, Justice D.Y. Chandrachud, to please share his thoughts with us on this momentous occasion.
Honorable Prime Minister of India, Shri Narendra Modi ji, my colleague judges of the Supreme Court of India, Chief Justice Obaidul Hassan, Chief Justice of Bangladesh, Justice Kinle Dorji, Judge Supreme Court of Bhutan, Chief Justice Bibi Rehana Mungli Gulbul, Chief Justice of Mauritius, Chief Justice Bishwambar Prasad Shrestha, Chief Justice of Nepal, Chief Justice Jayant Jayasurya, Chief Justice of Sri Lanka, Chief Justices and Judges of the High Courts, former Chief Justices of India and Judges of the Supreme Court of India, Mr. R. Venkatramani, Attorney General for India, Mr. Tushar Mehta, Solicitor General of India, Mr. Manan Kumar Mishra, Chairman of the Bar Council of India, Dr. Adish C. Agarwal, President and Executive Committee of the Supreme Court Bar Association, President and members of the Supreme Court Advocates on Record Association, Vice Chancellors of the National Law and other universities, members of the Bar, students, young and not so young, you're all students for our whole life, distinguished guests, ladies and gentlemen. Today is a momentous occasion in the history of our nation. The Supreme Court of India marks the commencement of the Diamond Jubilee year of the moment of its inception on 28 January 1950. First and foremost, I thank the Honorable Prime Minister of India, who graciously agreed to be with us, address the audience, and launch the new initiatives of the Supreme Court of India. I also extend my heartfelt gratitude to my esteemed counterparts from Bangladesh, Bhutan, Mauritius, Nepal, and Sri Lanka for joining us in commemorating this occasion together. India has long-standing cultural bonds with them, and the presence of the Chief Justices today strengthens India's ties with their nations. A conversation about this court must necessarily be prefaced with a conversation about the Constitution of India. It was through the Constitution that the people of our country gave to themselves this court. The Constitution is not just a legal document. Its soul lies in the feeling which it engenders, a feeling of mutual respect towards fellow citizens, a feeling of responsibility in the institutions which it creates. The constitutional ideals permeate the fabric of our nation, guiding the actions and interactions of both the governed and those who govern them. The Supreme Court was established with a sense of idealism, that laws would be interpreted by a constitutional court in accordance with the rule of law and not by colonial values or social hierarchies. It affirmed the belief that the judiciary should serve as a bulwark against injustice, tyranny, and arbitrariness. The Supreme Court is an institution of resolution and justice. The fact that people approach it in large numbers speaks to how far we have succeeded in discharging that role. Today is not only a celebration of that one day when the Supreme Court came into being, it also is a celebration of the decades' worth of hard work by succeeding generations of judges and lawyers that went into making this a people's court. In celebrating the history of this day, we must look back and look forward in equal measure. Since the founding of the court, our actions have been guided by Mahatma Gandhi's profound words: recall the face of the poorest and weakest man whom you have seen, and ask yourself if the step you contemplate is going to be of any use to him. Our decisions, both in the judicial and administrative realms, have been aimed at enhancing accessibility to the Indian judicial system for common citizens. Through its judgments, the Supreme Court has enhanced the rights of citizens by diluting the standards of local standi and by recognizing a new set of rights under Article 21 of the Constitution, such as the right to a speedy trial. On the administrative side, the Supreme Court has been identifying and eliminating as many barriers to justice: unequal access to legal resources, unfamiliarity of the English language, issues of physical accessibility of courts, in order to create procedural fairness. The e-courts project of the Supreme Court of India attempts to enhance accessibility and transparency of the justice delivery system. At the heart of these initiatives is the desire to transform the judicial system into a technology-enabled, efficient, accessible, and environmental-friendly institution. Let me briefly summarize the achievements of the court in simplifying its process. E-filing of cases. The front desk experience of approaching courts has changed completely. As opposed to lawyers lugging trolley carts of papers, we now have the facility of filing cases at the click of a button. An upgraded version of the Supreme Court's e-filing platform was launched in May 2023. It offers a host of improved features that have made 24/7 filing of cases simpler, faster, and convenient. Nearly 128,000 e-filings have been done so far, with a consistent rise in the share of e-filings compared to physical filings. E-filings are available in 25 states. They have recorded over 29 lakh cases which have been e-filed. With the immense support of the bar and the bench, we were able to swiftly shift to virtual hearings during COVID-19. Even after the pandemic, hybrid hearings continue to be a feature of our courts. That is, any Indian lawyer sitting in any part of the country or the world can argue before this court through video conferencing. This has democratized access to the Supreme Court. It has opened the space for those who are unable to approach the Supreme Court due to physical distance or want of resources. Even yesterday, one of my colleagues joined the bench through video conferencing for a special hearing on a Saturday. Till now, we have dealt with over 5 lakh cases through hybrid hearings. The live proceedings of the Supreme Court Constitutional Bench hearings are popular and speak to the genuine curiosity that people have towards our courts and procedures. Focus on scanning and digitization. The Supreme Court of India today operates in a near complete paperless mode, with almost all benches using digitized paper books. Judges are provided with scanned, bookmarked, and digitally signed case records, which they access, read, annotate, and preserve for their reference at their residences and in courtrooms. More than 13 lakh legacy and live case records, with approximately 10 crore pages, have been digitized. Futuristic courts. The Supreme Court has enabled futuristic court technology in 3 courtrooms, and soon other courtrooms shall be equipped with such technology. This technology facilitates paperless proceedings, a comprehensive digital library for the bench and the advocates, state-of-the-art video conferencing, large video walls, smart monitors, and document visualizers, all of which redefine the courtroom experience. Office automation. Adoption of e-office has enabled the officers of the Supreme Court Registry to perform their routine works in a paperless mode. 36 branches of the Supreme Court's registry have been onboarded on e-office, and more than 4,000 office files have been processed online so far. Suswagatam. Launch of the Suswagatam portal has enabled visitors to generate entry passes online in a paperless mode. A total of 1,23,000 entry passes have been generated so far using Suswagatam. We are also transcribing oral arguments in matters before constitution benches, which can be accessed on the Supreme Court website. The Supreme Court has entered into an MOU with IIT Madras to explore areas that can be completely automated and to leverage technology and artificial intelligence for enhancing process efficiency. As we speak today, a team of generative AI researchers at a premier management institute in Mumbai has built an end-to-end demo of an actual open-source Gen AI model trained in public domain motor accident cases. It is trained to automatically extract parameters from petitions, documents, and files, and give a recommended compensation figure. Together, e-filing, digitization, paperless courts, and e-office constitute the golden quadrangle of transformation within whose enabling perimeter the Supreme Court of India is set to uplift the experience of everyone who is either a part of the judicial system or who comes into contact with it. But what is the future? The Supreme Court is soon going to migrate its digital data to a safe, secure, and sovereign cloud-based infrastructure. This would be a shot in the arm for the IT setup of the court. Cloud storage would ensure privacy, integrity, high availability, and secure accessibility of the Supreme Court's domain data. We are also on the verge of opening a war room equipped with technology that would enable the Supreme Court to monitor judicial data of the entire country in real time by using the National Judicial Data Grid and iJuris, both of which were information sharing platforms. For the district judiciary, iJuris has been launched by the Supreme Court to monitor statistics of vacancies and infrastructure relating to the district judiciary. Facilitating free accessibility of judgments for citizens and litigants has always been a priority of the e-courts project. As of today, 36,209 judgments are uploaded online on the eSCR portal in English, out of which about 36,000 judgments have been translated into Hindi and around 11,000 judgments have been translated to other Indian languages with the help of AI-assisted machine learning. The Virtual Courts initiative has been a game changer in courtroom access and online dispute resolution. Implemented in 20 states, the initiative has received 4.37 crore challans, leading to a total collection of 502 crores of rupees in fines. Interestingly, according to the Electronic Transaction Analyzer of the Government of India, in 2018, e-courts had surpassed even the Indian Railways in terms of total electronic transactions. All 713 district courts' websites have been migrated to the S3VAS framework of the National Informatics Center, which offers a user-friendly interface, greater customization, and compliance with the guidelines for Indian government websites, thereby ensuring better accessibility for differently abled users. On the National Judicial Data Grid, a repository of nationwide judicial data, information on 3,256 countrywide courts, the High Courts, and the Supreme Court of India is now a click away. Just as we make our courts tech-savvy, we must also realize that India is going through a period of social and demographic transformation. Anyone who visits India will notice a striking feature of the changing demographics of the nation. Now, women can be seen in important positions across India, whether it be in the operation theaters, the borders of the nation, in the high skies as fighter pilots, in the seas as naval commanding officers, all across the country, and of course in the Supreme Court. There is a focus on greater inclusion of the marginalized sections of society. Equally inspiring is the confidence of the younger population to succeed in their professional lives. Traditionally, the legal profession was a profession of elite men. Times have changed. Women traditionally underrepresented in the profession now constitute 36.3% of the working strength of the district judiciary. In the recruitment examinations for junior civil judges conducted in several states, namely Andhra Pradesh, Arunachal Pradesh, Chhattisgarh, Delhi, Himachal Pradesh, Karnataka, Madhya Pradesh, Maharashtra, Odisha, Rajasthan, Sikkim, Uttar Pradesh, and Uttarakhand, more than 50% of the selected candidates were women recently. In the Supreme Court of India, we hire law clerks cum research associates to assist the judges, out of which 41% candidates are women this year. We as judges and administrations cannot be ignorant of these rising aspirations. Before the beginning of 2024, only 12 women were designated as senior advocates in the history of the Supreme Court over the last 74 years. Last week, the Supreme Court designated 11 women coming from different parts of the country as senior advocates in one selection. Our legitimacy will endure from the inclusion of diverse sections of the population in our system. Therefore, we need to make more efforts to bring different sections of society into the legal profession. For instance, the representation of scheduled castes and scheduled tribes is quite low, both at the bar as well as on the bench. In the near future, we must address the structural issues affecting the judiciary, such as the pendency of cases, our archaic procedures, and the culture of adjournments. Our effort in our work as judges and administrators must be to ensure dignity to the district judiciary, which is the first point of contact for our citizens. Our ability to remain relevant as an institution requires us to recognize challenges and begin difficult conversations. And I'll highlight 4 issues as I conclude on difficult conversations. First, we must emerge out of the adjournment culture to a culture of professionalism in our courts. Second, we have to ensure that the length of oral arguments does not interminably delay judicial outcomes and lead to the capture of judicial institutions by the powerful and the mighty. Third, the legal profession must provide a level playing field for first-generation lawyers, men, women, and others from marginalized segments who have the will to work hard and the potential to succeed. And fourth, let us begin the conversation on long vacations and decide, of course in consultation with the bar, whether alternatives such as flexi time for lawyers and judges is possible. The 75th year since the founding provides an opportunity to meet these challenges and step into the future with an honest assessment of our progress. We must reflect on the journey that we have traversed and renew our pledge to uphold the Constitution within and beyond our courtrooms. Our mission to make the judiciary accessible to all would be incomplete without the support of our high courts. I thank the judges and the staff of all the high courts, as indeed I thank my own colleagues and staff in the Supreme Court in facilitating our initiatives which are being launched today. Thank you. Namaskar.
Thank you so much, sir, for this insightful and eloquent address. Your words will continue to resonate with each one of us present here for all times to come. When the winds of change blow, some people and institutions build walls, while the others build windmills. Taking note of the winds of technological progress and change blowing across the world, the judges and the administration of the Honorable Supreme Court of India decided to embrace and harness the transformative power of technology to enhance accessibility, efficiency, and transparency within the judicial system. As the Supreme Court of India enters a brave new world of technological advancement, it continues to make incredible strides in its institutional journey. Today, we shall witness the launch of 3 citizen-centric e-initiatives of the Supreme Court of India, such as the Digital Supreme Court Reports, DigiSCR, the Digital Courts 2.0, and the new website of the Supreme Court of India. अब मैं माननीय प्रधानमंत्री जी से निवेदन करती हूँ कि वो अपने समक्ष रखे हुए रिमोट का बटन दबाकर इन इनिशिएटिव्स का औपचारिक रूप से लोकार्पण करें।
The Supreme Court of India has consistently striven to assimilate tools of technology in its core operations to enhance access to justice and improve administration of justice. Supported by National Informatics Center of the Ministry of Electronics and Information Technology, Government of India in this endeavor. The court has launched a series of citizen-centric services with the aid of IT. On the historic Diamond Jubilee celebrations, the Supreme Court adds 3 more initiatives to its repertoire of e-services. DSCR marks the commitment of Supreme Court of India to make its judgments available to citizens, especially law students and young lawyers, free of cost in easily accessible digital format. DSCR shall provide free access to all 519 volumes of the Supreme Court reports since 1950. Volume-wise, bookmarked and in open access, easily available for download. Users can view the reports in any mode of their choice. The reports can be accessed in standard HTML mode for quick viewing. One may choose the flip viewing option for book-like experience while browsing through any chosen report. The reports can also be viewed in a PDF format. Using DSCR, A user can easily cite and email the digital report to one or more persons. The platform provides multiple search parameters such as party name, year, volume, case type, etc. to enable wide searchability for the users. DSCR marks a monumental shift from print to digital format, contributing to environmental sustainability by eliminating carbon footprint associated with print publications. The Supreme Court of India has also launched the ESCR platform, which provides free digital access of its reportable judgments. ESCR is available in English and Hindi languages. To ensure wider access, the Supreme Court of India is translating its judgments in Hindi and other Indian languages using machine learning technology. Around 36,000 judgments have been translated in Hindi and nearly 11,000 judgments have been translated in other Indian languages. Digital Courts 2.0 has been launched by the E-Committee in collaboration with Department of Justice under E-Courts project to make court records available to judges of district courts, coupled with use of artificial intelligence for transcribing speech to text. Integration of Digital Courts 2.0 with NIC's artificial intelligence powered tool Shruti shall facilitate judges to dictate orders, judgments and record testimonies of witnesses on real-time basis, thereby ensuring a speedy judicial process.
संक्षेप में अभियोजन का मामला यह है कि 14 जनवरी 2016 को प्रातः 7 बजे अपीलकर्ता का दूसरे प्रत्यर्थी शिकायतकर्ता इसके बाद के साथ जल निकासी के मुद्दे पर विवाद चल रहा था.
The dictated text will be converted to document format using built-in template with QR code, case number, party details, advocates and name and designation of judge. Digital Court 2.0 will enable the presiding officer to speed up daily court proceedings, ensuring accuracy and efficiency, and also result in a big leap towards complete transition to paperless court. Presently, Shruti provides automatic speech recognition for 7 languages, namely English, Hindi, Marathi, Tamil, Telugu, Kannada and Bangla. The E-Committee intends to implement the Digital Courts 2.0 in a phased manner across district courts of the country. Marking another milestone in transparency and accessibility, the Supreme Court of India has, in close coordination with NIC, launched its brand new revamped website offering an improved user experience for citizens through its dynamic functional design, user-friendly interface and robust content management. The revamped website offers convenient access to a bouquet of information on the organization, quick links of essential technology-based services, key documents and important updates and notices for advocates, litigants, court officials and citizens. Developed within the S3WAAS framework of NIC, the new website ensures greater accessibility for differently abled users and is fully compliant with requirements of government websites. The website will be available in English and Hindi languages for wider access. Committed to make the judicial process accessible and efficient, the Supreme Court of India is all set to revolutionize the courtroom experience by adopting cutting-edge futuristic technology. Futuristic court technology has already been deployed in 3 courts, including Chief Justice's Court, with the remaining courtrooms to be equipped with such technology very soon.
On this special occasion, may I now request the Chief Justice of India, Justice D.Y. Chandrachud, to present a memento to the Honorable Prime Minister of India. अब मैं आदरणीय प्रधानमंत्री जी से विनम्र निवेदन करती हूं कि वो इस सभागार में उपस्थित सभी गणमान्य अतिथियों एवं श्रोतागण को अपने अमूल्य शब्दों से संबोधित करें।
भारत के मुख्य न्यायाधीश डी.वाई. चंद्रचूड़ जी, सुप्रीम कोर्ट के न्यायमूर्तिगण, विभिन्न हाई कोर्ट के मुख्य न्यायाधीश, विदेशों से आए हुए हमारे मेहमान जजेस, केंद्रीय कानून मंत्री अर्जुन राम मेघवाल जी, अटॉर्नी जनरल वेंकट रमानी जी, बार काउंसिल के चेयरमैन मनन कुमार मिश्र जी, सुप्रीम कोर्ट बार एसोसिएशन के अध्यक्ष डॉक्टर आदिश अग्रवाला जी, अन्य महानुभाव, देवी और सज्जनों, 2 दिन पहले भारत के संविधान ने अपने 75 वर्ष में प्रवेश किया है। आज भारत के सुप्रीम कोर्ट के भी 75वें वर्ष का शुभारंभ हुआ है। इस ऐतिहासिक अवसर पर आप सभी के बीच आना अपने आप में सुखद है। मैं आप सभी न्यायविदों को इस अवसर पर अपनी शुभकामनाएं देता हूं। साथियों, भारत के संविधान निर्माताओं ने स्वतंत्रता, समानता और न्याय के सिद्धांत वाले स्वतंत्र भारत का सपना देखा था। भारत के सुप्रीम कोर्ट ने इन सिद्धांतों के संरक्षण का निरंतर प्रयास किया है। अभिव्यक्ति की आजादी हो, व्यक्तिगत स्वतंत्रता हो, सामाजिक न्याय, सोशल जस्टिस हो, सर्वोच्च न्यायालय ने भारत की वाइब्रेंट डेमोक्रेसी को निरंतर सशक्त किया। 7 दशकों से भी लंबी इस यात्रा में सुप्रीम कोर्ट ने इंडिविजुअल राइट्स और फ्रीडम ऑफ स्पीच पर कई महत्वपूर्ण निर्णय किए हैं। इन फैसलों ने देश के सोशियो पॉलिटिकल परिवेश को एक नई दिशा दी है। साथियों, आज भारत की हर संस्था, हर संगठन, कार्यपालिका हो या विधायिका, अगले 25 वर्षों के लक्ष्यों को सामने रखकर काम कर रही है। इसी सोच के साथ आज देश में बड़े-बड़े रिफॉर्म्स भी हो रहे हैं। भारत की आज की आर्थिक नीतियां कल के उज्जवल भारत का आधार बनेगी। भारत में आज बनाए जा रहे कानून कल के उज्जवल भारत को और मजबूत करेंगे। बदलती हुई वैश्विक परिस्थितियों में आज पूरी दुनिया की नजर भारत पर है। पूरी दुनिया का भरोसा भारत पर बढ़ रहा है। ऐसे में आज भारत के लिए जरूरी है कि हम हर अवसर का लाभ उठाएं, कोई भी अवसर जाने न दें। आज भारत की प्राथमिकता है ईज ऑफ लिविंग, ईज ऑफ डूइंग बिजनेस, ईज ऑफ ट्रैवल, ईज ऑफ कम्युनिकेशन और साथ ही ईज ऑफ जस्टिस। भारत के नागरिक ईज ऑफ जस्टिस के हकदार है। और सुप्रीम कोर्ट इसका प्रमुख माध्यम है। साथियों, देश की पूरी न्याय व्यवस्था सुप्रीम कोर्ट के दिशा निर्देशों और मार्गदर्शन, आपके गाइडेंस पर निर्भर होती है। ये हमारा कर्तव्य है कि इस कोर्ट की एक्सेसिबिलिटी भारत के अंतिम छोर तक हो और इससे हर भारतीय की आवश्यकताएं पूरी हो सके। इसी सोच के साथ कुछ समय पहले ई कोर्ट मिशन प्रोजेक्ट के तीसरे चरण को स्वीकृति दी है। इसके लिए दूसरे फेज से 4 गुना ज्यादा राशि को मंजूरी दी गई है। ये तो आपका विषय है, ताली बजा सकते हैं। मनन मिश्रा में ताली न बजाए वो तो मैं समझ सकता हूं, वो आपके लिए कठिन काम था। मुझे खुशी है कि देश भर की अदालतों के डिजिटाइजेशन को चीफ जस्टिस चंद्रचूड़ खुद मॉनिटर कर रहे हैं। ईज ऑफ जस्टिस के प्रयासों के लिए मैं उन्हें बधाई देता हूं। साथियों, हमारी सरकार अदालतों में फिजिकल इंफ्रास्ट्रक्चर को सुधारने के लिए भी प्रतिबद्ध है। 2014 के बाद से इसके लिए 7,000 करोड़ रुपए से ज्यादा राशि वितरित की जा चुकी है। मैं वर्तमान सुप्रीम कोर्ट बिल्डिंग में आप सभी को आ रही दिक्कतों से भी अवगत हूं। पिछले सप्ताह ही सरकार ने सुप्रीम कोर्ट बिल्डिंग कॉम्प्लेक्स के विस्तार के लिए 800 करोड़ रुपए की धनराशि स्वीकृत की है। बस अब आप लोगों के पास कोई संसद भवन की तरह पिटीशन लेकर ना आ जाए कि फिजूल खर्ची हो रही है। साथियों, आज आपने मुझे सुप्रीम कोर्ट के कुछ डिजिटल इनिशिएटिव का शुभारंभ करने का भी मौका दिया है। डिजिटल सुप्रीम कोर्ट रिपोर्ट्स की मदद से सर्वोच्च न्यायालय के निर्णय अब डिजिटल फॉर्मेट में भी मिल सकेंगे। मुझे देखकर अच्छा लगा कि सुप्रीम कोर्ट के फैसलों को स्थानीय भाषाओं में ट्रांसलेट कराने की व्यवस्था भी शुरू कर दी गई है। मुझे उम्मीद है कि देश की अन्य अदालतों में भी जल्द ऐसी व्यवस्था हो सकेगी। साथियों, आज टेक्नोलॉजी कैसे ईज ऑफ जस्टिस में मददगार साबित हो सकती है, इसका एक कार्यक्रम अपने आप में एक उदाहरण है। मेरा ये संबोधन अभी एआई की मदद से इसी वक्त इंग्लिश में ट्रांसलेट हो रहा है और आप में से कुछ लोग भाषिणी ऐप के माध्यम से उसे सुन भी रहे हैं। कुछ शुरुआती दिक्कतें हो सकती है, लेकिन टेक्नोलॉजी कितना बड़ा कमाल कर सकती है, ये इससे पता चलता है। हमारी अदालतों में भी इसी तरह की टेक्नोलॉजी का उपयोग करके सामान्य नागरिकों का जीवन आसान बनाया जा सकता है। आपको याद होगा, मैंने कुछ समय पहले कानूनों को सरल भाषा में लिखे जाने की बात कही थी। मैं समझता हूं कि अदालत के निर्णयों का आसान भाषा में लिखे जाने से आम लोगों को और मदद मिलेगी। साथियों, अमृतकाल के हमारे कानूनों में भारतीयता और आधुनिकता की समान भावना दिखनी भी उतनी आवश्यक है। वर्तमान की परिस्थितियां और बेस्ट प्रैक्टिसेस के अनुरूप सरकार भी कानूनों को मॉडर्नाइज करने पर काम कर रही है। पुराने कॉलोनियल क्रिमिनल लॉज को खत्म करके सरकार ने भारतीय नागरिक सुरक्षा संहिता, भारतीय न्याय संहिता और भारतीय साक्ष्य अधिनियम की व्यवस्था शुरू की है। इन बदलावों के कारण हमारे लीगल, पॉलिसिंग और इन्वेस्टिगेटिव सिस्टम ने नए दौर में प्रवेश किया है। एक बहुत बड़ा परिवर्तन है। सैकड़ों वर्ष पुराने कानूनों से नए कानूनों तक पहुंचने का परिवर्तन सहज हो, यह बहुत जरूरी है। इसके लिए पहले ही सरकारी कर्मचारियों की ट्रेनिंग और कैपेसिटी बिल्डिंग का काम भी शुरू कर दिया गया है। मैं सुप्रीम कोर्ट से आग्रह करूंगा कि वो भी सभी स्टेक होल्डर्स की ऐसी कैपेसिटी बिल्डिंग के लिए भी आगे आएं। साथियों, एक सशक्त न्याय व्यवस्था विकसित भारत का प्रमुख आधार है। सरकार भी लगातार एक विश्वस्त व्यवस्था बनाने के लिए अनेक निर्णय कर रही है। जन विश्वास बिल इसी दिशा में उठाया गया कदम है। इससे आने वाले समय में न्याय व्यवस्था पर बेवजह पड़ने वाला बोझ कम होगा। इससे पेंडिंग केसेस की संख्या भी घटेगी। आप जानते हैं कि सरकार द्वारा अल्टरनेटिव डिस्प्यूट रिजोल्यूशन के लिए लॉ ऑफ मीडिएशन की व्यवस्था भी की गई है। इससे भी हमारी न्यायपालिका, विशेष रूप से सब ऑर्डिनेट जुडिशरी पर पड़ने वाला बोझ कम हो रहा है। साथियों, सभी के प्रयास से ही भारत 2047 तक विकसित भारत के लक्ष्य को प्राप्त कर पाएगा। और इसमें निश्चित तौर पर सुप्रीम कोर्ट के अगले 25 वर्षों की भी बड़ी सकारात्मक भूमिका है। एक बार फिर आप सबने यहां मुझे निमंत्रित किया। आप सबके ध्यान में शायद एक बात आई होगी, लेकिन ये फोरम ऐसा है कि मुझे लगता है कि उसका जिक्र करना मुझे अच्छा लगेगा। इस बार जो पद्मा अवार्ड जो दिए गए हैं, उसमें सुप्रीम कोर्ट के रिटायर्ड जज और समग्र एशिया की पहली मुस्लिम सुप्रीम कोर्ट जज, उनको इस बार फातिमा जी को हमने पद्म भूषण सम्मान दिया है। और मेरे लिए ये बहुत गर्व की बात है। एक बार फिर मैं सुप्रीम कोर्ट को उसके 75 वर्ष पर बहुत बहुत बधाई देता हूं। बहुत बहुत धन्यवाद।
आदरणीय प्रधानमंत्री जी, आपके गरिमामय उद्बोधन के लिए हम तहे दिल से आपको आभार व्यक्त करते हैं। Finally, I request Justice B.R. Gavai, Judge Supreme Court of India, to kindly deliver the vote of thanks.
Honorable Prime Minister of India, Shri Narendra Modi ji, Honorable Chief Justice of India, Dr. Justice D.Y. Chandrachud, Mrs. Chandrachud, my distinguished colleague Justice Sanjeev Khanna, and my esteemed colleagues on the bench, former Chief Justices and former judges of the Supreme Court of India, Chief Justices and judges from the judiciaries of Bangladesh, Bhutan, Mauritius, Nepal, and Sri Lanka, Union Minister of State of Law and Justice, Shri Arjun Ram Meghwal ji, the Learned Attorney General for India, Shri R. Venkatramani, Chief Justices and Judges of the High Courts, Shri Tushar Mehta, Solicitor General of India and the law officers, Shri Rahate, Secretary Justice, Shri Nitin Chandra, Secretary Law, Chairman of the Bar Council of India, Shri Manan Kumar Mishra ji, President of the Supreme Court Bar Association, Dr. Adish Agarwala, and all the office bearers, Shri Manoj Mishra, the President and other office bearers of SCORA, members of the Bar, Registry, and citizens of India who have joined us virtually. I am honored to propose a vote of thanks in an event which marks the beginning of the 75th year of the Supreme Court of India. This institution was envisaged with tremendous expectations as India shifted from a colonial system to a constitutional system. The framers of the Constitution considered the right to approach the Supreme Court to seek remedies against violation of rights so important that they incorporated it in the Fundamental Rights chapter itself. The constitution of the Supreme Court symbolizes the balance of justice which the framers intended to create. That is an institution that will act as a shield for the citizens against the excesses of power. The preamble of the Indian Constitution reflects the ideals of justice, liberty, equality, and fraternity, emphasizing the commitment to securing justice for all citizens. The Supreme Court, as the apex judicial authority, plays a central role in ensuring the realization of these ideals. Referring to Article 32 of the Indian Constitution, which provides for citizens to approach the Supreme Court, Dr. B.R. Ambedkar, the chief architect of the Indian Constitution, once said, and I quote, "If I was asked to name any particular article in this Constitution as the most important, an article without which this Constitution would be a nullity, I could not refer to any other article except Article 32. It is the very soul of the Constitution and the very heart of it," unquote. Over the last 74 years, the Supreme Court has indeed acted as the heart and soul of the Constitution. Through its judgments, the court has safeguarded the rights of citizens on numerous occasions. Today's event provides expression to the commitment which the judges have carried in the last 74 years. Today, we have also launched a few new initiatives. This shows the continuing dedication of the court to make its process accessible and feasible for the common citizen. The Constitution also emphasizes on social and economic justice in addition to political justice, as Dr. Ambedkar has stated in his last address to the Constituent Assembly on 25th of November 1949. It cannot be denied that in the last 74 years of the functioning of the Constitution of India, all the three wings of the state, the legislature, the executive, and the judiciary have worked towards achieving the goals of social, economic, and political equality. In particular, the judiciary and the executive adopted a collaborative approach to ensure that the Supreme Court keeps on working at its full strength. The judiciary, the parliament, and the executive have been emphasizing on the need for diversity and representation of various sections of society in the judiciary. We have been making active effort to ensure this, and our effort shall continue. Since the Honorable Chief Justice of the High Courts are present here, I would earnestly request them to keep this in mind while making recommendations of elevations for the various High Courts. I thank the Honorable Prime Minister of India from the bottom of my heart for sparing time from his busy schedule to join us and share his thoughts and vision today, and also for launching the new initiatives of the Supreme Court of India. I extend my thanks to the Chief Justice of India, who as the head of the family of Indian judiciary, took a lead in organizing today's extraordinary event. I am grateful to Honorable the Chief Justice of India for fulfilling the long-standing demand of installing the statue of Dr. B.R. Ambedkar in the premises of the Supreme Court of India, and also for giving me an opportunity to play an important role in the said project. It is only because of Dr. Ambedkar and the Constitution of India as framed by him and his colleagues, a person like me who began his schooling in a municipal school situated in a slum area could reach to this position. I'll be failing in my duty if I do not place on record my deep appreciation for the efforts taken by the learned Secretary General and the team of the Supreme Court Registry involved in this project in completing the task in the shortest possible time. Thanks to my colleague Justice Sanjeev Khanna and my other colleagues from the bench for their contributions in today's event. I also thank Shri Arjun Ram Meghwal, the Union Minister of State for Law and Justice, for his continuous support in our endeavors. I also thank distinguished guests on the dais and off the dais, including Honorable Chief Justices and Justices from the neighboring countries, respected former Chief Justices of India and judges of the Supreme Court, Honorable Chief Justices and judges of the High Courts, and the members of the bar for taking out time from their schedule today. Lastly, I thank the Supreme Court Registry and its staff for organizing this event so efficiently. Under the leadership of the Chief Justice of India, the registry comprises senior officers and young officers drawn from different parts of the country, whose combined energy forms the backbone of the working of the Supreme Court. We look forward to the year-long celebrations that will be organized by the Supreme Court of India over this entire year with a focus on engaging with the citizens. As it is said in Marathi, Janteche Kalyan ha pahila kaida hai. People's welfare is our first rule. Thank you very much. Jai Hind.
With this, we come to the end of the program. I request the august gathering here to kindly wait until the Honorable Prime Minister and other distinguished dignitaries leave the auditorium.
तो सुप्रीम कोर्ट की हीरक जयंती समारोह की तस्वीरें हम आपके साथ साझा कर रहे थे। आपको बता दें, प्रधानमंत्री नरेंद्र मोदी ने यहां पर इसका उद्घाटन किया और साथ ही अपने
और
अभी बैठने की कृपा करें। जब वो पैदल चलकर आएंगे तो आपको लग जाएगा। वो पैदल आने के लिए उन्होंने सूचना दी है, वो पैदल आएंगे। अभी बैठ जाइए। मैं उत्तरी भाग के संतों से निवेदन करता हूं, बैठ जाइए, बैठ जाइए।